Is the Sexual Assault Reform Act an unconstitutional violation of the Ex Post Facto Clause? To find out, you have to read People versus Superintendent of Woodbourne Correctional, but it's 57 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I try to cover New York Court of Appeals cases in 5 minutes or less. This is the episode on the case of People versus Superintendent of Woodbourne Correctional Facility. This can be found at 2023 New York Slip Opinion 03229, published by the New York Court of Appeals on June 15th of 2023. The issue in this case is the constitutionality of the SARA rule, which requires level 3 sex offenders to live more than 1,000 feet away from school grounds. To understand what's going on in this particular case, the background is important. You have to understand a little bit about what SARA is and what Ex Post Facto law is. So SARA is the Sexual Assault Reform Act. It was first established in the year 2000 and then amended in 2005. And the goal of the law, by the legislature's intent, was to protect children from dangerous sex offenders. Originally, it applied to sex offenders who committed offenses against minors. And in 2005, it was amended to apply to all sex offenders that are level 3 and commit certain crimes under the executive law. And the effect of it is that you can't live, if you're one of these people that it applies to, you can't live within 1,000, you have to live more than 1,000 feet away from school grounds. So schools, daycare centers, colleges, training facilities, things like that. And the result is that DOCS, the Department of Corrections, will not release a person who's subject to these rules until and unless they have compliant housing. So if you're under these rules, DOCS won't let you leave. You'll stay in jail until you find compliant housing. And in New York City, in particular, it's very hard to find compliant housing just because 1,000 feet is a lot, especially given the density of New York City. So the second part you have to understand is what an ex post facto law is. An ex post facto law is a law that either makes something criminal that was not criminal and charges them for it, or increases the punishment of an offense after the person committed the offense. So if you make something criminal that was not criminal and you charge someone for doing something when it was not criminal, that violates ex post facto law. Or if you elevate the punishment, it violates the ex post facto law. So what are the facts here? In 1986, which is, just to place it here, this is 10 years before SORA exists. This is 14 years before SARA exists. It's 20 years before the SARA amendment in 2005. This particular plaintiff, this petitioner, who was the prisoner, he was 16 years old, and he and 4 others committed basically mayhem. They shot at people, they shot people, they murdered people, raped people, terrible. And they were sentenced, the defendant was sentenced to 20 years to life in prison. And the to life is important. To life means that he's subject to post-release supervision for the rest of his life. So all the rules will apply to him for the rest of his life. And in 2019, after 33 years after his conviction, he was granted an open parole release date, meaning he finally can be released. And he was adjudicated a level 3 sex offender, which makes him under that SARA provision, where he can't live within 1,000 feet of school ground. He couldn't find a place that would be compliant, and they wouldn't let him leave for that reason. And he was there for an extra 21 months or so. And he filed this lawsuit, basically saying, applying this SARA rule to me, or this is what he says, to himself, years, a decade or more after he committed the offense would be a violation of the Ex Post Facto Clause. The trial judge agreed. The trial judge ordered his immediate release. It goes to the appellate division. They disagreed and reversed it. It goes to the Court of Appeals. And here we have 3 different decisions. The majority decision says that the appellate division was right. The trial judge was wrong. They go through this analysis. They say, to determine whether there's a violation, an unconstitutional violation of the Ex Post Facto Clause, which is found in Article 1, Section 9, Clause 3, requires a 2-part test. The first part, it's called the intent effects test. The first part is, what was the legislature's intent in passing this law? If it's punitive, done. Violates ex post facto. If it's not punitive, you go to the second part. And that question is, what are the effects of the statute? If the effects are punitive, making it more punitive than civil, then that violates the ex post facto clause. And they go through the fact that there's a presumption, there's a strong presumption that it's constitutional. And to overcome that presumption, you have to have the clearest of proof. That's the words they use, clearest proof. And they go through the fact there's a case, a federal case called Hudson, and it established 5 factors the court has to consider to determine whether in that second prong, whether the effect of the statute is so punitive as to render it a violation of ex post facto. And the 5 factors are, number 1, does the statute create affirmative restraint? That's punitive. Number 2, does it resemble historically criminal punishment? That would be punitive. Number 3, does it promote the traditional aims of punishment? That would render it more punitive. Number 4, is it rationally connected to non-punitive purposes? And number 5, is it excessive in relation to the non-punitive purpose? They go through those factors and they say that the most important factor is number 4. And there's a non-punitive purpose here, which is to protect children. And because it's rationally related to that sufficiently, it survives the ex post facto challenge. There is a dissent by Judge Rivera and Judge Wilson, and they say every single one of those factors makes it punitive, shows that even though the intent might not be punitive, the effect is punitive, such that it violates ex post facto. In particular, because they point to studies that show the SARA rule actually harms, it makes it more likely that people will be recidivists with respect to sex offenses, and therefore it fails that 5-factor test in the second prong, and it would be violation of ex post facto. And finally, there's a dissent from Judge Halligan, who would remit it down to the appellate division to make further findings as to whether it's excessive in relation to the non-punitive goal. And that's the case of People versus Superintendent of Woodbourne. Remember, the ultimate conclusion here, the majority is it does not violate the ex post facto clause. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.